Debri Den, good afternoon, distinguished chair, distinguished representative of the Federal Bailiff Service of the Russian Federation, distinguished speakers, participants, ladies and gentlemen. It is a great honor for me to take part in this roundtable discussion and to share Indonesia's perspective on enforcement-related functions within the Ministry of Law of the Republic of Indonesia. I would like to express my sincere appreciation to the Federal Bailiff Service for convening this important discussion. The theme of this roundtable is highly relevant because enforcement is not merely a technical stage after a court decision has been issued. Enforcement is closely related to the credibility of the justice system, legal certainty, and the effective protections of the people's rights. In many legal systems, the enforcement of court decision is commonly associated with bailiffs, judicial officers, or enforcement authorities attached to the judiciary. In Indonesia, the direct enforcement of court decisions in the classical sense is generally carried out within the judicial systems under the Supreme Court of the Republic of Indonesia. However, the Ministry of Law also performs several important functions that are closely related to the legal consequences of court decisions or court determinations. These functions are not enforcement in the narrow sense of executing a judgment. Rather, they are enforcement-related functions that support the implementations of legal determinations, the administration of assets, and the protections of civil rights. One of the key institutions in this regard is the Probate Office. The Probate Office is a technical implementing unit under the Ministry of Law. The role is rather unique because the office is tasked to represent and administer the interest of certain legal subjects in relation to court decisions, court determinations, or legal interest in the field of civil matters. In practical terms, the Probate Office represents the presence of the state in protecting civil rights when certain persons are unable to manage or protect their own legal interest. This includes, among others, supervisorship of legal guardian to the minors and legally incapable persons, persons in legal absence, statute trustee in bankruptcy, and other parties whose civil interests require legal protections. Distinguished participants, there are several functions of the Probate Office that are relevant to today's discussions. First, it performs functions in relation to guardianship. This is important to ensure that the interests and assets of minors remain protected. Second, it performs functions in relation to or legal guardianship for adults who are declared legally incapable of managing their own affairs. Third, it performs functions in the context of situation where a person is absent and unable to manage his or her legal interest. In such situations, based on the court determinations, the office may be appointed to administer the assets and legal interests of the absent person. Fourth, it may act as a state curator in the administration and settlement of bankrupt estates. In this role, the office supports the orderly settlement of assets and obligations following a bankruptcy decision issued by a commercial court. Distinguished Chair, at present, Indonesia has 5 probate offices. These offices are located in several cities in Indonesia. The number may appear limited when compared to the size of Indonesia, its population, and its geographical complexity. However, institutionally, the existence of 5 probate offices also corresponds to the 5 commercial courts in Indonesia. This shows that the office is positioned to support the administration of legal consequences arising from civil and commercial cases, particularly bankruptcy cases in the main commercial justice regions in Indonesia. Based on the Office Register Book as 24th of May 2026, there were about 1,199 ongoing services handled by the 5 offices across Indonesia. This case appears rather mundane, but when we delve deeper, the figure shows that the functions of the probate office are not merely one-time administrative services. Rather, they often require continuous supervision, administrations, asset management, and settlement until the relevant legal process is properly completed. For example, guardianship supervision may continue until a child reaches adulthood. Bankruptcy administration may also require a long process involving asset management, creditor-related processes, settlement of obligations, and final accountability. In this sense, the office plays a supporting role in ensuring that legal determinations do not stop on paper but are followed by practical administration and protection of rights. Distinguished participants, there is also interesting development in the functions of probate office, particularly in relation to absent persons. Traditionally, the administration of assets belonging to absent persons was often associated with physical assets such as land and buildings. However, in recent developments, the office has also started to deal with intangible assets, including shares. In some recent cases, the probate office was appointed by the court to administer shares owned by shareholders whose whereabouts were unknown in the context of a go-private process of public company. In such cases, the office may be recorded as a party representing the interests of those shareholders. However, this does not mean that the shares may become the property of the probate office. In this particular point, the office only acts as a representative and administrator to ensure that the rights of the absent shareholders remain protected. The development is important because it shows the asset administration must adapt to the changing nature of assets. Assets are no longer limited to physical objects. They may also include shares, securities, digital records, and in the future, possibly other complex forms of property and economic value. For Indonesia, this is one of the reasons why the discussion on enforcement should not be limited to the physical execution of court decisions. It must also include the broader ecosystem of asset administration, protection of rights, institutional coordinations, and legal policy reform. Distinguished Chair, from the perspective of Ministry of Law, this issue also connected to the broader legal policy reform. Indonesia continues to reform its legal system, not only in the field of criminal law, but also civil law, private international law, and the governance of legal institutions. In the field of civil and commercial matters, one of the important challenges is the recognition and enforcement of foreign judgments. These challenges become more complex in cross-border situations, including insolvency, assets located in different jurisdictions, and legal relations involving foreign legal subjects. At present, Indonesia is developing a draft law on private international law. This draft law is expected to provide a clearer framework on issues such as jurisdiction, applicable law, and the recognition and enforcement of foreign judgments in civil and commercial matters. This reform will lead to a better legal certainty because it will provide a clearer legal basis for cross-border civil matters and open wider opportunities for international legal cooperation. This is particularly relevant for discussions with institutions such as the Federal Bailiff Service in Russia, which has extensive experience in court decision enforcement, centralized enforcement administration, and asset-related implementation. Distinguished participants, in my capacity as Director General of Legal Policy Strategy Agency, I see the topic is not only about institutional matter, but also as a legal policy issue. The question is not only who performs enforcement. The broader question is how legal system can ensure that court decisions align with legal certainty and fulfillment of civil rights. At the same time, Indonesia is also pleased to share its own experience in developing enforcement-related functions within the Ministry of Law, particularly through the probate office, legal policy reform, and the modernizations of public legal services. As a closing note, I would like to underline that enforcement is not only about authority, but it's also about the responsibility to ensure that legal institutions continue to adapt to the needs of society and the realities of our time. Indonesia remains committed to strengthening its legal institutions, improving legal services, and learning from the experiences of other countries. We hope that today's discussions will enrich our collective understanding and strengthen future cooperation. Thank you very much. Spasibo vнимание. Thank you.
Jelajahi cara baru mendapatkan informasi. Download MetroTV Extend sekarang.